report from HBRIC with their updates. Looks rather brief here, but perhaps not so.
Well, good afternoon, Chairman, or should I say Chairperson. First, can I introduce, because I think not all councillors know everybody. So Danelle Dinsdale from our board, Jim Scotland. I'm Andy Pearce, obviously the Chairman of HBRIC, and Blair O'Keefe, who's our Acting CEO. Blair's been with us since about May. I don't think we've formally introduced him to you in previous meetings. So he's been here with us to manage the transition from Andrew being the CEO before he came back to council, so that we would have a well-dressed and well-informed acting CEO. As you know, we're in the process of seeking to appoint a part-time CEO, and we expect to make an announcement about that in the reasonably near future. Can I congratulate on behalf of the board all the councillors on your election results, and congratulate the chairperson and deputy chairperson on their election to their respective roles.
Thank you.
If I may, I won't deal with the report in the sequence that it's set out. I'd like to speak very briefly to Napier Port, a matter to do with Napier Port, because potentially that'll get lost in the larger discussion if we don't deal with it now. And that is to give you a heads up that at your meeting on the 30th of November, we'll be bringing recommendations to you for appointments, an appointment and a reappointment of 2 directors to Napier Port. We had those recommendations ready for this meeting today, but we were advised you wouldn't be able to deal with that on your agenda today, so we will come forward at the 30th of November. That is getting pretty tight for the timelines for notice for their annual general meeting, which is on the 19th of December, so that decision will need to be made on the 30th. They are at their constitutional minimum number of directors of 6. So while there is machinery in place for the chief executive to step into a single director position, that would still only leave them with 5 directors. So we need to make director appointments for them to be in compliance with their constitution. So we'll speak to you about that in a public excluded session on the 30th of November. And we can provide the paper earlier if that would be of assistance. There's an even better method. Thank you. In relation to the RWSS, I'll just make 4 kind of headline points, key points if you like, and then Chairman will deal with questions if there are any, and I'm sure there will. So in no particular order, since September, we have progressively cut back expenditure on this. Obviously, we're now going to the Supreme Court, and so many things are on hold until that matter is progressed and resolved. To give you an indication, we're currently spending around about 1/8 of the average monthly expenditure that we've incurred over the last 12 months. So we've cut that back pretty severely, and only spending on the bare minimum of things to do with the RWSS. Our constructor JV and our co-investor remain committed to the project, and they're awaiting the outcome of the land exchange litigation, and we're spending nothing in either of those areas. Without wanting to traverse into what I think is going to be the next agenda item, which is about your review process, I understand that that's going to be taken after this. I simply want to say that at HBRIC we would welcome such a review. It gives council and new councillors in particular the opportunity, and returning councillors, to carefully consider council's position and have a consolidated view of all of the information. The Supreme Court process on the land exchange will take some months. We don't know how many months that is, but it'll certainly be some months, because there's at least a two-stage process. There's the application for leave and then a hearing. So there's time for a review of a period of several months at least to be completed. We'll assist that review if you decide to undertake it in any way we can. Obviously that review has to be undertaken by independent parties, and we're perfectly comfortable with that. But information that's required for the review and so on, of course, it will all be available from us. The fourth thing is that in the briefing pack that we've provided for incoming councillors, one of the questions or one of the decisions that we raised was appointment of councillor directors onto HBRIC, and we suggested a timing for that in that paper. Well, that paper was written a while ago, and various things have moved along since then. And we want to suggest to you that you consider whether or not you might want to make some councillor directors on HBRIC now. That would align quite well with your review process. Would mean that there's strong alignment between the two organisations, with some councillors being directors of HBRIC. We've always had the view that having HBRIC directors was a perfectly feasible proposition. It's provided for in the constitution of the company, and it's only a council decision some time ago that took councillor directors away to avoid perceived conflict of interest. We believe those conflicts can be managed, and as I say, we would, if you wish to do that, then we would welcome the appointment of some HBRIC directors, some councillors as HBRIC directors. So those are the headline points that I wanted to make, and we're happy to take questions. We'll share them around among us.
Thank you, Andy, appreciate that. Any questions or thoughts about the report? Tom?
Yeah, I just have a couple of questions about the money aspect of this. You say you've been trimming this back, but if I'm reading the report accurately, there was still about $380,000 spent in September, and that struck me as wow, that's cutting back. And so what might October look like? Would we, at the November 30 meeting, for example, be able to get an October update of where things are? Is 380 what we would expect the going forward rate to be, or something less than that? Or
Certainly talk to that. There's two aspects to the sum for September. One is that we were originally targeting financial close at the end of September, so there are a series of costs associated with trying to conclude all of the commercial agreements and all the legal work that needed to be done. They have effectively been switched off now, but there were a series of costs incurred leading into that timetable that were commitments that needed to be honoured in terms of paying out for services provided. The second part of it relates to us starting to basically reorganise the costs going forward, so they will drop down, as the Chair mentioned, to about an eighth of the costs that we've been incurring on a net run rate basis.
so there were various references, if I can find one, like on page 69 of our papers, it's the first page of your report. 3 paragraphs from the bottom, is it noting the requirement to meet previous contractual commitments?
Yes.
What are some of these previous contractual commitments that represent an ongoing commitment at this point?
Those are the items related to predominantly to the timetable to achieve financial close at the end of September. So there was a series of due diligence work being done by various parties, including financial institutions relative to the investment, as well as legal costs associated with working with the agreements associated with that due diligence as well.
And the largest item that I noticed here was the landowner negotiations.
Yes.
What is that?
So that item, which you note, represents costs over the last 3 years. So that's a contractual commitment that was associated with activity over the last 3 years. So that's effectively a make-up cost over a period. It's not what will be an ongoing cost. It's a contractual commitment associated with the last 3 years of activity.
I think, Lee, you've got an indicative number though for the sort of monthly spend, is it?
Yes, it should drop down to, we're talking tens of thousands now versus the number you mentioned being 400,000. It will drop down substantially.
And one last question, if I may. The 2.9 million that is the geotechnical work, somewhere it is also referred to
It's bid costs.
as a something else cost.
Yes, that's bid costs. So that's costs for the constructor for the design work that they've done throughout the previous few years of preparing for the project, and they were contractually committed as well. So
It's shown in that line because that line is the costs paid to the contractor. That's why we spelled out in the report that no geotechnical work has been done and that this is solely to pay part of their costs of bidding for the contract.
So they would have incurred their own, I assume as a competitor for the project initially, they would have borne their own cost of putting together a reasonable proposition to us. We're not paying for that. We're paying for, subsequent to them being appointed as the contractor, we've asked them to do further design work.
It principally pays for design work, so as a result of paying that amount of money, the IP and the design belongs to HBRIC going forward, and it also is offset as a contribution towards any contract once it's awarded.
I mean, I would just note that I've raised an issue about the adequacy of the independent review, and what this is saying to me is that we've spent $3 million on design work, and yet we're maintaining we don't have any design work that is that should have been independently reviewed as a condition of the Board of Inquiry consent. Seems like a lot of design work to not have any of it reviewed independently as we were told to do.
Chairman, I think that's a different piece of subject matter which we'll be happy to traverse in more detail at an appropriate time, but it would be fair to say our view of the conditions that are set out are different from Councillor Belford's. So I'll say that again. We'll be happy to traverse this in more detail with Council. Oh, well, that's. I'll take that as a compliment. Thank you. We'll see how we do as the meeting progresses. Not a problem as far as I'm concerned, sir. So we have a somewhat different view about what the conditions require from Councillor Belford's, and I'm not sure that Councillor Belford's aligns necessarily with Council's own view. We will be happy to traverse that matter and at a later date and in a suitable forum.
You happy with that answer?
Thank you, Chair. So just humour me a bit here, Dr. Pearce. What things do you think we need to review in any such review? What are the touch points in your view?
So I think we're stepping outside the space of our report and into the next agenda item, and I'm going to consistently say on questions about that to the Chairman, could we deal with those questions when we get to the next agenda item? And that's a matter that Council Management have prepared a paper for you on. I think Council Management should speak to their paper, and we're happy to answer questions when they've done that. Otherwise, you're asking us to do their job for them or speak to their proposition before they've had an opportunity to do that. I don't think that's appropriate.
Just as a follow-up, so are you happy, Chair, that HBRIC will be available to us, for us to ask questions when we deal with that next paper? Or do I need to pose some questions now?
I hadn't considered that, but I think that's probably a good idea. You can wait for the following paper.
Of course, we'll be happy to do that.
Okay, then I think we'll take it there. Yeah, you want to
Okay,
hold your
that's fine.
questions till then?
So I've only got one other question I'd like to ask, and it's in relation to the legal costs that we've incurred to date with the court case. And I did raise this with you by email, and I was hoping that you might clarify. So what has it cost for us to to be represented in the 2 court cases on the land swap that we've been involved in to date?
We're just preparing a paper on that right now in response to your request. Unfortunately, our financial advisor or controller has been away on leave, so pulling it out line by line and invoice by invoice is the level of detail we're going into, and he's just preparing that for my review this week. So as soon as we have that available, happy to share that.
I think, though, indicatively at this stage, we will have spent more on the High Court appeal than we will have on the Supreme Court, because thus far for the Supreme Court we have simply filed an application for leave, and we have filed our submissions, which are less than 10 pages. So that won't amount to a substantial sum, whereas there's months of work and substantial costs involved in the High Court appeal. And if you want to know the whole answer, then we will have to go back to the Court of Appeal case. Then we will have to go back to the High Court for the judicial review of DOC's decision as well. So they've got this. So there's 3 different pieces, and they span over a whole year.
With respect to the the Supreme Court appeal, could you outline to me the rationale and justification for HBRIC being a party to the case, rather than simply leave the matter to the Department of Conservation to file the appeal?
So I'm going to ask Danelle, who's our legal person, to address that question.
We have different interests. We both are seeking perhaps an end result that might be useful to both parties, but they're from different perspectives. The Department of Conservation are looking for an answer to how they should be dealing with their entire conservation estate, whereas we are looking at access to this particular piece of land. So they are quite different approaches in terms of the arguments that you provide to the Supreme Court. And I think that the importance of this case for us to get access to that land is extremely significant, whereas for the DOC approach, they have an overarching need to understand how to run their estate. It's a longer term requirement. They aren't so interested in the specific piece as we are.
I haven't read the legal briefs particularly, so I'm just going up general, but as I understand it, the decision that Forest and Bird took and the ruling of the Court of Appeal is about the generalities of it, not a specific case. And this is about how the law applies to the transfer of these lands in a general sense. That being the case, I could understand the Department of Conservation wishing to appeal it, but when we have a particular case, I'm struggling to see why we would be engaged with it on that. That's what you've said is very obvious. I could have said it myself, they're in general and we're particular, but you haven't actually addressed my question. My question is, given that the DOC are appealing the case, which is on the general principles of law, which I can understand DOC going to, why are we there with a particular case when this is an argument about the general application of the law?
There are 2 reasons. One is the fact that we have a degree of urgency which is not the same for DOC, and therefore that is an important aspect that only we are able to bring and DOC is not, because of our particular need rather than their general position. And the second part is that there is another issue which hasn't been dealt with in the previous appeal case, which is on the marginal strips, which is particular to our requirement for that piece of land. So we have a different and specific extra aspect which would not be otherwise covered by the DOC approach.
Just a follow-up question to that, Daniel. How disadvantaged would be if we asked you not to participate further in that court case until the review is completed?
I personally would feel that it was fundamentally problematic to our whole preservation of our rights for the council, for the ratepayers.
Sorry, please close that. Fundamentally problematic to our rights as ratepayers.
Well, if we have an investment in the dam to date, I mean, we need to go through the process, have the cup of tea that Councillor Graham has recommended, and understand what you want to do. But in order to make that decision, that requires a certain length of time to have it. I think we've got plenty of time before the Supreme Court even sits, frankly. But making a decision today not to spend the money on that would potentially make a decision as to whether or not you had a dam.
Any other questions?
My main question is obviously in the next agenda item, but Andy, just in light of some of the media, can you please confirm that the water sales to date are 45.6?
Sorry, that hasn't changed.
So that's the figure? Because last time we were here and I was told it hadn't changed, but then one of my colleagues put it at 42.8, and that's been in the media ever since. So I'm just clarifying the correct figure.
It's whatever we reported to you, not what any of your colleagues might think it is. It's what we reported it to you. And if it's 45.6, and that's some months ago, so you were testing my memory here as to the exact number. What we reported to you last, no one has withdrawn a contract that I'm aware of.
Thank you very much, team. That's an excellent report.
Can we move to have you receive that report then, Chairman?
Yeah, no, we're just about to do that.
Good, thank you.
So we have the report. Do we have a mover and a seconder to accept this report? To receive the report. Mover, seconder. All those in favour? Aye. Do you wish to speak? Either of you two? Okay. Righto. We accept the HBRIC report. Now we're going to move to item